And as customary, we start with a pledge. I ask Denise to lead us in the pledge. Thank you, Mrs. Karcher. I appreciate that. Sarah, now I'll come to you for the roll call and determination of quorum.
Mr. Peterman?
Here.
Mrs. Karcher?
Here.
Mr. Servan?
Here.
Mr. Galvery?
Here.
Mr. Mills?
Here.
Mr. Davis?
Here.
Mr. Jester?
Here.
So you have 7 present. You do have a quorum.
It's certainly good to see everybody present tonight. I think it's probably been a couple years since we all been here, so I thank you all for coming to the meeting tonight. I would also ask that anybody in the audience who has a phone or other electronic device that you make sure it's either on vibrate or it's turned off so it won't disrupt our meeting. You also have in front of you now the agenda for tonight. If there's any additions or corrections, if not, I'd ask for a motion to approve in a second.
So moved.
I have a motion and a second. Sarah, call the commission.
Mr. Peterman?
Yes.
Mrs. Karcher?
Yes.
Mr. Servan?
Yes to approve.
Mr. Galvery?
Yes to approve.
Mr. Mills?
Yes to approve.
Mr. Davis?
Yes.
Mr. Jester?
Yes,
So you have 7 yeas in favor of approving tonight's agenda.
I thank you very much. Commissioners, you also have in front of you tonight the minutes for March 10th, 2022. If there's no additions or deletions or anything to those, I'll once again call for a motion and a second.
Motion to accept.
Second.
I have a motion and a second. Sarah, call the commission.
Mr. Peterman?
Yes.
Mrs. Karcher?
Yes.
Mr. Servan?
Yes.
Mr. Galvery?
Yes.
Mr. Mills?
Here. Yes.
Mr. Davis?
Yes.
Mr. Jester?
Yes.
So you have 7 yeas in favor of approving the minutes of March 10th.
Also in front of you, you've seen what the levy court action was on our on the projects that went before them. If you have any questions, please contact staff. Going down to new business for tonight. First one is CS-22-02 Calpines Kent County Solar Energy Center. Request for conditional use with site plan approval of a solar facility, public utility located outside the growth zone overlay district. We had the for and the against, and I will now turn it over to the commission for a question, Mr. Davis, or are you going to make the motion? Okay, go ahead with your comment.
Thank you, Mr. Chairman. I would just like to bring to the attention of the commissioners, I have a lawsuit that has been filed in the Delaware Court of Chancery, case number CA-2022-0287, which was filed by the Goldsboro family regarding the first application that we did, in fact, approve upon Route 9. And the lawsuit is against the Kent County and the solar panel company itself. It consists of 25 pages, and I've taken a lot of time to read it. I read it 5 times. And we've sat here and we've heard a lot of debates, both sides, for and against. I feel very strongly that because this zoning application is coming before us this evening in AC property is basically the same thing that's talked about in this pending lawsuit before the Delaware Court of Chancery. The only difference is the issue of location. They're both AC property, and I feel that because this lawsuit, the first part of it basically talks about procedural things with the levy court, which has nothing to do with us. But the rest of the lawsuit addresses the issue of AC property As I mentioned, it's a 25-page lawsuit. It's been filed in the Court of Chancery. I personally think it would be inappropriate at this time is to carry this application and vote on it tonight because of the close similarity of the AC property debate that's now going on in the state of Delaware. So I think we would be wrong to vote on this application. I would rather see what the Court of Chancery says about it because it will have a drastic effect, maybe even on some of the ones that we have approved. And it would definitely have an effect should they rule in favor. If we vote on this thing tonight, I just think it's wrong for us to proceed with this because I think this needs to be cleared away, and the court system has got all the facts, and I would like to say that each commissioner get a copy of this Court of Chancery lawsuit. I got it by accident, and it's public record, and I have that lawsuit. And when you read both of them, and I don't think many commissioners on the RPC is even aware of the lawsuit, and I have it here tonight. So I'm going to make a motion because of the pending lawsuit that this application be tabled until the decision of the Delaware Court of Chancery resolves the AC issue about solar. As we know, we passed, the levy court did pass for community solar. And from what I heard of all the testimony, there were really no major issues with that. But when you read this lawsuit, I think it will really raise your attention as to should we be making this decision or should we do the right thing and let the Delaware court make that decision based upon the law. So I'm going to make a motion that it be tabled until the court case itself is resolved, or if the commission would rather, that it be tabled for 6 months. We've done this before. We have set a precedent, and I'm referring to the rezoning down Sussex County or Kent County about the people who wanted to have the motorcycle track down there. We tabled that for 6 months. So we set a precedent on that. It'd probably be better if we wait to the Court of Chancery and gives everybody an opportunity to really see it. Because I really think by you not reading this court civil suit against the Kent County Levy Court and the solar provider, I think that would be that'd be an injustice to all. And I want to be fair about this thing, and I want to hear all the evidence, the pros and the cons, and I want to see what the court's decision is. So I'm going to make a motion that to table this application until the Delaware Court of Chancery resolves this lawsuit that I made reference to.
Thank you, Mr. Davis. I have a motion on the table. Is there a second?
I second.
I have a motion and a second, and Denise has a question.
I have a question. First of all, I just want to put on the record that this is less than half in AC and the rest of it is in AR, so it is different. I don't think we can compare it completely. It's not apples and apples. But I have a question of staff. If this gets tabled for X period of time, then it comes back. The fact that let's not worry about what is decided at court level. Will this still be considered having been started before we had the
Before the new ordinance?
yes.
It's still considered an active application, and it predates the ordinance, so it would still be active.
Oh, okay, thank you.
I respectfully disagree with the planning director. The application, when it was submitted, has nothing to do with the lawsuit. It doesn't even mention that. it talks about the issue of AC property, that it's not proper, it should be in an industrial zone, and I happen to agree with that. So the director and I have a difference of opinion, and I have it here. It's a shame that I'm really surprised everybody didn't get a copy of this. I don't know what the big secret is. It's a matter of public record. It's 25 pages, and so I keep my motion on the floor that it will be continued till we get a decision from the Court of Chancery. If that doesn't pass, then perhaps we can do it in 6 months. I would respectfully hope that it would be done within 6 months. So my motion's still on the floor. If I need to make an amendment, we can do that also. Thank you.
I have a motion on the floor and a second. Is there any more questions? Mr. Peterman?
This piece of property is both AG and AR, AC and AR. How much of it is AC? Do we know? Do we have any idea? I asked that question and say, if they would take out the part of AC, will that make it legal? And could we vote on that part of the AC only? Excuse me, Sarah. That question was for you. I just looking the other way.
I think you're splitting hairs when you do that. A case is a case.
I think you might be right, Paul, but I just wanted to make sure for me before I vote.
Potentially, the Planning Commission could recommend to the levy court to limit development to the AR zoned portions. And levy court could do with that what they'd like.
Could you mind repeating that and speak up? I have a hard time hearing a little bit.
My response to Mr. Peterman was potentially the commission could recommend to the levy court that development be limited to the AR portion of the property, and then levy court can do with that what they'd like.
You have a question, Mr. Davis?
Well, you know, a lawsuit's a lawsuit, and this property that we're going to vote on, or was going to vote on, is AC. And they talk about things in the application to the court. I didn't know this, and I don't even know if I agree with this, that they're supposed to go for the PLUS program and then go before PLUS. That's State Planning Commission, all the agencies. Unless I missed it, I didn't see it in any of the documents that we got. And they also say that failure of solar electric generation facility is to qualify as a public utility under the zoning codes. And they say a lot of things in here. If the commission didn't want to accept this motion, then it should be at least tabled for 30 days so everybody has an opportunity to read this. And I know the commissioners haven't read them because I've asked them. I'm not going to vote on this thing tonight. I think it's wrong. I think that's why we have courts, and I respect their decision. They may say everything's okay, but they're not suing the county just for the fun of it. This is a big issue in our county. So that's my position on it. You have any other questions? If I can answer them, I'll be glad to do it.
Yeah, one more question, please.
Mr. Peterman?
In your statement, you said that a motion, you want a table for how long?
I can leave that up. You know, I'm flexible. I can leave that up to the commission. You know, if you would prefer 6 months, like we have on other occasions, we set a precedent, we can do that. If you would prefer to vote it down, you can do that, but, you know, my motion. Or I'll go with your advice if you want it till the court makes a decision. If the court makes a decision and we do something else, then we're going to say it back here again. and there'd be a lot of litigation over this thing. So I'm open to suggestions, how you would like for me. If you don't like the motion I made, I'll be more than happy to make an amendment to my motion and change it.
One more question.
I think we're going to have the motion reread, Sarah, over what the motion was so that the commission actually knows what we're talking about. You got a question first, Mr. Mills?
Yeah, the question, the plaintiff in this lawsuit that you're speaking of, are they the same group of people that objected to this project here?
To my knowledge, no. I don't think it's the same people.
Yeah, they spoke.
Are they the same ones that did the Smyrna deal? No, I mean, are they the same party that we approved up on Route 9? I don't think so. It's a different party.
No, the ones that spoke opposition to this project are the same ones that are listed on the plaintiff on that project there, right?
Yeah, I believe that's correct because it was the
My
Goldsboro.
mistake,
yes.
I didn't understand. Yeah, my mistake, yeah.
But I think we need clarification on what his motion was in a second so we know what we're voting on. Would you like to clarify that, Mr. Davis, or you want Sarah, you want Mr. Davis to clarify it?
The motion is to table. The question now is for what period of time?
I'll include in my motion, and feel free to amend the motion. I'll make the motion till a decision is reached by the Delaware Chancery Court regarding AC solar panels.
I think you'll have to have your second also agree on the change of the motion.
I'll second the change.
Okay, once again, I need it reread to the commission so we know exactly what we're either voting for or against.
As I understand it, the motion is to table this application until the litigation related to a previous application is resolved.
That would be correct.
That would be correct, and so if that's being straightened out, you can now call the commission.
Mr. Peterman?
Yes.
Mrs. Karcher?
No.
Mr. Servon?
No for the motion.
Mr. Galvary?
Yes.
Mr. Mills?
Yes.
Mr. Davis?
Yes.
Mr. Jester?
No.
So you have 4 yeas, 3 nays in favor of tabling application CS 2202.
In that case, I'd like to make another motion, which I have a right to do that.
And according to this project then, or how is the motion going to be? Okay, go ahead with your motion. We'll see what it is.
I would make another motion that it be tabled for 6 months until, and look at it at that time. Hopefully the court would have it resolved by then. So rather than...
We've passed the motion that it's going to be tabled until the court takes care of it, so there's no need to put a time limit on it.
Well, I'll tell you, I don't know how the courts work sometimes. They're a little bit slow, sometimes they're not. But I also want to put in that motion. See, the problem I'm having here, in all due respect to everybody, I don't think everybody's seen this. And I think you need to read it and then make your judgment. You haven't read the court, you haven't read the court case. So how can you make an intelligent decision unless you know what's pending before the court that is directly consistent with what we're doing here with AC property? That's what it's all about, AC property.
Well, I think you have a motion in place that already says this isn't going to be acted on until the court decision. Go ahead, Sarah.
I would agree with the chairman. You've got, the application is effectively tabled. I would suggest the chair could speak with the county attorney when he returns. And should you choose to take it up sooner, we can put it back on an agenda if you agree.
Yeah, I think we better go by what the attorney would say with it.
I'm having a hearing problem. What was that, Sarah? Could you speak?
The application is effectively tabled. The question has been solved. I suggested to the chairman that when the county attorney is available, he can have a conversation with him And should he choose to bring it back up for consideration, he can do it then.
The county attorney is part of the lawsuit.
Right, but there's no need, being it's effectively tabled for the duration until it's satisfied, there's no need to put any kind of limit on it for time-wise. I mean, your motion said that this particular application would be tabled until it's, till the courts actually satisfy what's being brought before them. Yeah, but there wasn't no need for another motion because it's already been taken care of.
All right.
Excuse me, Paul, just a second. May I say something?
I'll make another motion. I can make all the motions I want.
Okay, hold on a minute. Mr.
I
Peterman's
just
got
have
a question.
Can we say, if the court makes a decision within 30 days or 60 days, can we say that they can come in instead of 6 months?
That's
Okay,
correct. We're under jurisdiction of the court decision.
Then they can immediately after the court makes a decision, if it's in 30, 60 days, they don't have to wait 6 months.
I question that.
Okay, hold on a minute. Denise had a question for you, Mr. Mills.
I don't have a question. The vote was 4 yes and 3 no, am I correct?
Yes, the application is
Done.
tabled.
It's done. I don't understand why we're
It
still
is not
talking about
done.
this.
A commissioner can make as many motions as he wants, and look in the rules of the RPC, and you'll see that.
Is your motion pertaining to this particular application that we just tabled until the court decision?
The first motion I made was turned down.
No.
No,
It passed. It passed. It's that
so much going back and forth, I got to remember this.
Yeah, this particular application, the Calpine Kent County Solar Energy Center, is now tabled until the decision of the courts is made.
My mistake, my apologies. This is what happens when you get older, so I apologize. I didn't understand it that way. I thought it was turned down, but it passed.
It passed 4-3.
Thank you for the clarification.
Are we done then?
We are done.
So that particular application is now done. Now going to number 2 on the new business tonight, CZ-22-02, LC-22-03, Pearson's Corner Farm LLC. It's a request to amend the zoning map from AR, agriculture residential, to low-density residential to BG, general business, highway commercial located outside the growth zone overlay district. I now have that on the floor. Does the commissioners have any other comments? If not, I would entertain a motion for that particular project. Denise.
Yes, I make a motion we move that the Regional Planning Commission recommend approval of ordinance LC 22-03 to amend the zoning map from AR, agricultural residential, low-density residential, to BG, general business, highway commercial, located outside the growth zone overlay district. And this is based on Exhibit A, staff recommendation report dated April 7, 2022, and Exhibit B, the public hearing testimony dated April 7, 2022, and the findings of fact that A, the character of the surrounding area is a mixture of highway, commercial, and industrial land uses. B, the proposed BG zoning would be compatible with the surrounding area. And C, the land use strategy map of the 2018 Kent County Comprehensive Plan indicates that the subject site be utilized for neighborhood commercial purposes. However, the land use chapter of the comprehensive plan provides the compatibility with surrounding land uses and availability of infrastructure should have equal weight on evaluating rezoning applications.
I have a motion. Do I have a second?
Second.
I have a motion and a second. Sarah, please call the commission.
Mr. Peterman?
Yes, to approve.
Mrs. Karcher?
Yes, to approve.
Mr. Servon?
Yes to approve.
Mr. Galvry?
Yes to approve.
Mr. Mills?
Yes to approve.
Mr. Davis?
Yes to approve.
Mr. Jester?
Yes, for all the reasons given.
So you have 7 yeas in favor of recommending approval of ordinance LC 2203.
Thank you very much. We now go into our third application. It's LC 22-09, solar moratoriums. An ordinance to amend Kent County Code, Volume 1, Chapter 158, moratoriums, as amended by the adding a new section relating to acceptance of conditional use site plan applications for public utilities, solar installations over 50 acres in size. Before I turn this over to Commission, this particular moratorium as presented tonight, which would be good through June the 8th, am I correct?
That's correct.
And right now, as you see it, and you told us last week, there's nothing in the pipe stream that this would affect, correct?
There are no applications that have been submitted, correct, that would be affected by this.
Hearing all that, does any of the commissioners have any more questions on this particular moratorium? If nobody has any questions, I'll ask for a motion. Who would like to make the motion? Is anybody? Mr. Davis, would you like to make the motion, please?
I'll make a motion that we approve.
Okay, Mr. Griffey, appreciate that. Go ahead.
I move the Regional Planning Commission recommended approval of Ordinance LC 22-09, enacting a 3-month moratorium on the acceptance of solar installations over 50 acres in size. This is based on Exhibit A, Staff Recommendations Report dated April 7th, 2022, Exhibit B, Public Hearing Testimony dated April 7th, 2022, and the findings of fact that the moratorium will allow time for potential amendments to existing solar regulations to be developed and evaluated without additional development pressure.
Second.
I have a motion and I have a second. Sarah, call the commission.
Mr. Peterman?
Yes, to approve.
Mrs. Karcher?
Not voting at all. I find it a little unsettling that this comes in front of us the month after we and the levy court, am I correct, both pass the new ordinance, and now suddenly the new ordinance, a brand new ordinance, is not good enough, apparently, because you're going to have I have to assume that a moratorium is so that they can make changes to something that hasn't even is barely taken effect. So I'm not voting.
Mr. Servon?
Yes, to approve.
Mr. Galvery?
Yes, to approve.
Mr. Mills?
Yes, to approve.
Mr. Davis?
Yes, to approve staff recommendation.
Mr. Jester?
As it's come before us, and I just don't see the reasoning of it, I'm going to take the same position that Mrs. Karcher did. I don't see the need for this because it's only going to be through June the 8th, and I just don't see the need for this particular moratorium.
So you've got 5 yeas, 2 not voting in favor of recommending approval of Ordinance LC 2209.
Thank you all. Our final application tonight is SL-5-04, revised 49 Pines Phase 1 and 2, request revisions to landscape plan located inside the growth zone overlay district. Sarah, would you like to explain what's actually going on with this, and I'd appreciate it.
Sure. As initially approved, there was a line of indeed 49 pine trees at the entrance of this subdivision. The trees that were there originally ultimately had to be taken down, I think partly due to their health and partly because of the right-of-way that was required. Now, DelDOT will not allow trees to be put within their right-of-way, and the homeowners along the road were not in favor of having the trees put in on their properties. So the applicant, the owner of the subdivision, has asked if instead those trees could be placed within open spaces. This is unfortunately not an uncommon situation where we've got homeowners who don't want the trees. So it seems like a reasonable compromise. Staff would recommend approval of it.
So this would straighten out their objections as far as you're all concerned.
The homeowners would be happy, and it would be compliant with our development code.
Okay, sounds good to me. Does any of the commissioners have any question about this particular application? If not, I'll entertain a motion. Denise?
I move that the Regional Planning Commission grant approval of the revisions to the 49 Pines landscape plans, superseding the plans recorded November 3, 2021. With this approval, the following requirements must be met. First of all, the plans must be revised and re-recorded to include all items contained in this memo and the requirements of the Regional Planning Commission, and that all proposed landscaping shown on the recorded plans must be planted and inspected by the Planning Department prior to granting any further dwelling building permits.
I have a motion. Do I have a second?
Second.
I have a motion and a second. Sarah, call the commission.
Mr. Peterman?
Yes to approve.
Mrs. Karcher?
Yes to approve, but I have to say that it just happens that about a week ago, I was driving right by this subdivision, and I thought, I wonder where they're going to put those 49 pines that I demanded that they have, or they weren't allowed to call it 49 pines. So now I'm glad I know.
Mr. Servan?
Yes for approval.
Mr. Galvary?
Yes to approve.
Mr. Mills?
Yes to approve.
Mr. Davis?
Yes to approve.
Mr. Jester?
Yes to approve.
So you have 7 yeas in favor of granting approval of the revisions to application SL 0504 and SL 1001.
Thank you, and good luck with the project. We're now down to public comment. Is there any public comment present for tonight? Say. Please give us your name and address. And sir, we don't have anybody to swear or affirm her.
It's fine, I'm not.
Okay, go ahead.
Tricia
And
Nash.
just give your address.
Okay, 3652 Big Woods Road, Smyrna, Delaware, 19977.
Welcome again tonight. Go right ahead.
Thank you. I just wanted to say thank you for what I consider doing the responsible thing with the first application for Calpine. That lawsuit I'm not a part of, but I do know about. And I think that you guys did do the right thing tonight. We appreciate that. I think the state and the county need some time to get laws in place. The second comment I have is for the moratorium, because there seems to be some confusion. If you go back and you listen to the minutes or the video of the hearing with Levy Court and with everyone else, and I've been in all these meetings with this ordinance was adopted with the understanding that there would need to be amendments made, that there would have to be necessary changes, both to benefit the solar, the community solar, and to benefit the residents of Kent County. So that's why the moratorium is also being put in place on top of the ordinance, is so that we can actually work together as a team and get this right for everyone in Kent County. It's not that we're opposed to solar, it's not that we're trying to restrict more, it's that we're trying to get it right. And I just wanted to make that clear for everyone. So thank you guys very much for your time. Thanks for hearing our concerns, and thank you for listening.
Thank you for your comments. Seeing no more public comment, we're down to commission comments. Any comments for the commissioners?
I
Peterman?
have a question. Wherever Paul got that information about that court hearing, can we get a copy of that?
Sir, would you see that the commissioners get a copy of that lawsuit? I appreciate that. Any more commission comments? If not, we're down for a motion to adjourn.
Motion to adjourn.
Second, anybody?
Second.
I have a motion and a second. Please call the commission.
Mr. Peterman?
Yes.
Mrs. Karcher?
Yes.
Mr. Servan?
Yes to adjourn.
Mr. Galvary?
Yes to adjourn.
Mr. Mills?
To adjourn.
Mr. Davis?
Yes to adjourn.
Mr. Jester?
Yes to adjourn. And thank you all for coming.